Welcome, everybody, back to one more time, Dirk. See? Okay, we can cut anything. Welcome, everybody, back to another episode of Counsel Table. Newsflash, we actually have a table this time. So that's an improvement. Yeah, this is brand new.
We're on couches.
You should have seen the last setup. It was uncomfortable, but it worked.
Omar is a slacker and slacks back, this is much more professional.
Oh, good.
Today we have two very important guests, Judge Miller, Judge Reeder. How are y'all?
Doing great. Thanks for having us.
Great.
Yeah, so just a little background. If you never heard of Judge Miller or Judge Reeder, you probably haven't practiced law that long. But Judge Miller's in the 190th in Harris County, and Judge Reeder is in the 234th. We're going to get to learn a lot about them, I'm sure, throughout this podcast. But, we want to focus on just a variety of topics with you guys. This is what Will calls our wonky legal podcast. That term has been sticking with it for some reason, but we're trying to educate our viewership, learn a little bit, but we also like to throw in some fun. And I do want to start with our fun story that we got to hear a little bit about. Rule number one: when you walk into a courtroom as a gentleman, wear a tie. Judge Miller, can you tell us a little bit about what you've been seeing lately?
Well, I think I have a reputation now as making sure that people are dressed appropriately for court. And I think that during COVID, we had a real decline on how you present yourself in court for a judge. And so the case that people like me to talk about is I have a case I call the tie case. So a plaintiff lawyer was asking for sanctions against a defendant for not appearing at a mediation. And there's an order to appear, and they should have appeared. But he himself was not wearing a tie. And so I looked at that as unclean hands. So I gave him half the money he was asking for, which a sanction's a big deal. So I gave him half the money he's asking for, but I told him explicitly that it's the most expensive tie he never bought, because if he'd worn a tie, he would have gotten all of it. Later that day, it came back to me that I sanctioned him for not wearing a tie, which is not true, because I gave him half the sanctions he was asking for. The next time the case came in front of the court, one of the defense lawyers was not wearing a tie. And so...
Same case?
Same case.
Lessons learned
Didn't learn his
concept?
lesson.
Yeah.
Didn't learn his lesson. So I had one of my law clerks go get a tie, brought it out for him. We passed the case until he was appropriately dressed. And then...
Not just any tie, though, right?
he went and got one of my nicer ties, which then I was upset with my law clerk. But anyway, but the good thing is that the next time I saw the case, all the lawyers there were 3 lawyers in that case, all bought the same kind of nice tie that we provided to them in multiple colors. And they were very excited, very happy for it. So I think there's a good lesson learned and a good outcome.
So if we come into the 190th without a tie, do we get a free tie? That's what I'm hearing.
Decent tie. This is a nice tie.
A nice tie.
It was nice to know we got the tie back.
Oh, there
we
we go.
definitely got the tie back. But no, you don't get a free tie.
And use the 190th. Am I the only person that has to Google what court they're in by number and also check the marquee and what floor they're on?
Judge Miller is the 190th.
And you are?
I'm the 234.
Did you know that already?
I said it already.
I only knew I only knew Judge Miller's because...
good.
333rd.
There you go. Ding, ding, ding.
I was going to say, I only knew the 190th because my very first trial ever was in Judge Miller's court. And you probably don't even remember that because it was with my father. I just become licensed 6 months prior. I like to say I did opening and closing. Opening the briefcase, closing the briefcase. But yeah.
Was I nice?
Yeah, very nice.
Okay,
great.
great.
We won. It was wonderful,
You were new.
I was new.
Okay.
So I was actually Judge Miller's second ever trial,
Right.
and it was fun. We were all learning. Let's just say that I think that was my second or third trial of my career, and we got to do a lot, and we talked a lot. I think you were also it was a personal injury case, so just what we learned. And then I think at the end of the trial, you're like, I've changed a lot of how I'm going to do things because I let you guys get away with way too much.
Great.
And it was nice because we were like, oh, all right, we got an hour for voir dire. We got, we got to do all this. He's like, I got to shorten this up, guys.
Never again.
Yeah, it was fun.
Never again.
Well, it's kind of like, lessons learned for lawyers, but we learn as well. I mean, we've been on the bench now almost 7 years, which is a long time. And I think back to my first 6 months on the bench, and I'm like, I kind of feel bad for some of the people that were probably first appearing in front of me. because you're still figuring out things too, and figuring out how you want to do things. And, I wouldn't have done things drastically different, but we kind of learned, best practices also. So thank you all for being patient with us all those years ago so we could kind of get our feet.
It's fun how I think when you're practicing in courts and you start seeing, you're like, oh, I think this is how they'll rule, but now it's shortened by 15 minutes or it's
Right.
we know what's going to happen. So that's not us, but you guys at least, I think.
I think so,
Well,
generally.
yeah, we learn for every case, I think. And the good lawyers and the not so good lawyers.
Yeah.
We learn a lot. So I was talking about that today in a trial. But we've learned. For the good, maybe.
But yeah, going back to the tie thing, I mean, I have noticed a lack of formalities amongst lawyers. And it's not just young lawyers or junior lawyers. It's kind of everyone. I don't know if it's a post-COVID thing, if it's just a kind of modern times thing. I mean, I think I was telling y'all, footwear also, I've noticed a lot of more casual footwear in the courtroom. Again, I think decorum is important. I mean, but I don't know if someone has
Yeah. Are you seeing a lot of sneakers?
Yeah, like some more formal sneakers, like the seat sneakers with the suit, and it's like a look. Others that are not so much a look and just a choice. But I think that it's like just make the easy choices, because you don't want somebody, a judge, a juror, looking at you and making a decision, a decision, right or wrong about you because of just something that could have been rectified by just putting on a tie or a different pair of shoes.
Do you guys ever judge the socks?
Oh, the socks. You probably do.
I don't. No, I don't. I just the ties,
He
but
has
not
a
the
good
socks.
sock game. I don't really ever look at. I don't. Now I'm gonna look at y'all socks now.
I'm a sock guy. So
Yeah.
I do not own a pair of solid socks. They're the stripe pattern or something. Mm-hmm. I'm more of the Rusty Hardin approach, is the jury knows you're a lawyer. There can be too much flash, but I don't need to put my Joe Jamel feet on the table with holes in the shoes and pretend I'm something I'm not.
Right.
But I'm not tops and tails, but I'm not going to, dress down, Hirshhorn style as much as possible. But I will wear a little flash. Like I wore a pair of hand-painted patina shoes to try in court. But I knew I didn't have any witnesses. I did have witnesses. I was pacing in the well. I do switch it up depending upon, like tomorrow, no witnesses. So I might be a little more bold in my colors and my shoes. No, I won't be walking around the well for people to see, but we'll see.
I almost judged him for he said he was wearing a green tie. I was like, plaintiff's lawyers can't wear green.
No, I wore green, so I posted some on social media. So this
Did
is
you
the
hear that,
ritual.
though?
This is you guys both tried cases in your practice. You obviously try cases now and sit with a black robe and a gavel in your hand, not a hammer or gavel. I have worn the same blue hop sack blazer to pick every jury for the last 5 years, 20 of them. And the same kind of ritualistic, I'm a pitcher, I don't step on the chalk as I leave the field, kind of baseball ritual guy. And this trial this week, 2 weeks ago, I said, I'm not doing that anymore. I looked at my wife and said, I'm going to wear something different. I wore green. And Marie Jameson, our friend, was like, ooh, you wore the money green. I didn't mean it. I just wasn't going to wear that damn blue hop sack blazer anymore. So I did change it up.
I had a defense lawyer wear a green tie a lot, and they had actually mock tried it, and he was told not to do it. And he did it anyway, and the case settled. And he asked about the green tie, and the jury said you shouldn't wear the green tie.
Because of money?
Yeah.
Really?
That's so I'll wear it to when there's a hearing. Hearings I'm a little different than I am with a jury, but especially in your court, I feel like it's who can wear it best. Because the other day you wore a lavender suit. I think I texted about 5 people. I was like, I gotta find where this suit is from. It was beautiful. So, but it's kind of more fun to dress up when you go to hearings, because I think times have changed a little bit. But I think with a jury, you still have to be a little more reserved in certain
Is that like a
aspects.
steak wearing a green tie today to take a witness?
Maybe.
I guess time will tell.
I guess we'll find out in a week. Yeah, exactly.
And criminal lawyers dress differently than family lawyers dress differently than civil lawyers.
Yes.
Have you noticed
Yeah.
that? You can always
Criminal
tell
lawyers have some flair.
if you call it that.
Some of it, it's some of it they want up here. I'm wearing a pinstripe. I'm in bold pinstripes. Look at me. I'm flamboyant.
And-
Trust me.
And pattern on pattern on pattern.
Can't do that.
Well, they try.
Steve Harvey-esque.
Yes, it's
It's a choice.
aggressive. It's a choice. It's a life choice, actually. Yes.
I remember, so I love sport coats, blazers, always have. I think I got it from my dad. And I think in the first, 3 months I was working with Steve Kirker, Tommy's dad, he's like, hey, we're going to go to court for this thing. He's like, don't wear one of your loud blazers, though. And I was like, well, I know that. But it was like, I don't even know what it was, but it was just, he's like, don't wear one of those. And then he looked, he's like, but I like them. I was like, well, it's fine. But I get it. I mean, every once in a while you can do it. I wanted to do it with Judge Sandel a long time ago. I had a Christmas suit. It was like reindeer, red. And I was like, I have a hearing in his court. And I just was young enough to where I was like, oh, I could get in trouble for this. So I was like, I'm not going to try it. But now I think I might try it in around Christmas time, it'd be fun if it still fits.
Well, now
If it still fits.
now that he's in the wild, I saw him sitting recently, and he was wearing an orange blazer.
Oh,
Very, very, not auburn, not rust.
Orange.
Yeah.
There you go.
Good for him.
do what you want.
Yeah. So while we're talking about being on the bench, I know you guys are running for re-election right now, at least coming up in 2026. But you're campaigning right now, correct?
Yes.
How's it going?
Yes.
We are. It's crazy to think that, it's almost November and, a year out from the general almost. And so we are on the road and going around and trying to do everything we can to get ready for 26. We're excited.
I'm fortunate because Lauren and I do a lot of things together. So it's nice to have a campaign buddy that's well respected, more than I am. And so it's nice to be on her back. But
Yeah, I mean, this job is so, it's an amazing job. Being a trial judge is so much fun, but it can be really isolating. It's great to be able to talk to lawyers and see lawyers and have people in the courtroom. But your day to day, it's not collaborative. You're not on a team necessarily, kind of popping into each other's office saying, "What do you think about this idea? What do you think about this? Or what if we do this?" We bounce ideas off of each other or ask questions sometimes amongst ourselves. But we have our offices. You have to really be going to see us if somebody's coming by your office. Nobody's just happens to be walking by. So it can be kind of an isolating position, and being a public figure and having to run for office and meeting people, we kind of hold our cards close to our chest sometimes. We're a bit guarded. So it's nice in this to have a friend and to have folks to do this together. The judicial canons don't let us, endorse each other, and we can't, collaboratively run, but we can do things kind of side by side. And it's just nice to have somebody that understands what we're going through to do it together.
So this will be your third time?
Yeah,
Third time, yeah.
Third time. Which is it's flown by, and we've just gone through so much between coming out when we were first elected and getting on the bench in 2019, where we were still sharing courtrooms with the criminal judges. If y'all remember back then,
The
before
flood.
Or
some
to take
Harvey.
the elevator to get an hour early for your hearing as you waited for the
Right, exactly. We were all in that together, and then COVID hit, and so we were dealing with remote hearings and jury selection at NRG. So much has happened in the last 7 years, and here we are gearing up for a third run, and hopefully things will be more normal in our next term.
well,
We always say they will.
I think people have to realize that Harris County is bigger than the 27th state or something like that.
Yeah.
I forget the number, but we've got 4.x amount of people in the state. Louisiana has 2-point-something million people in the entire state, or sorry, in the county. And so there's a lot of different groups that want your attention at night. So we're trying to be full-time judges and full-time in the community, which is important because I think you can bring that community aspect of the different people who you meet with back into the courtroom to understand where people are coming from, because we all have our own experiences. So I think it is an important facet of what we do for a living. However, it really takes a toll on you by your health and what you eat and how much time you have for your people at home. I have a partner at home, but you have kids and a husband and a dog.
I know. It's crazy.
What's the latest status on Harris County getting more courts?
Yeah.
We awarded 5 or 10 more courts.
The great Judge Bo Miller helped usher that through.
Well, Judge Lauren Reeder also helped with that. We were a great team with that.
We had a road show.
We had a
It was
road
great.
show. We have a lot of stories in the road show, but it was a real lengthy process involving the Commissioner's Court and the state ledge and the governor. And it all worked out for us for the first time since 1983. We've got 5 new civil courts coming. originally they were scheduled to be 3 this October and 2 next September. That was the original bill that was vetoed by the governor. And then it came with the first special, and it was 3 starting January 1st and 2 starting in September 1st. And now what passed in the second special is 3 starting next September and 2 starting next October. So 5 coming on board next year.
It has to do with the way the fiscal year works. So there'll be 3 at the end of fiscal year 26 that'll be funded by fiscal year 26, which ends at the end of September of 2026. So that's why 3 of them will come on board then. 2 more will come on in October. But it's essentially 5 at the same time.
So the 28 year?
Yeah.
The 28 year
Yeah.
election then?
So there'll be 5 appointments next fall, and then they will be on the 28 ballot.
Yeah, so they'll be appointed for 14 months, 14 months, and then they'll have to run. So it'll be great when it happens. I was really disappointed that it isn't happening sooner because we have these huge dockets, and I think the better it is for litigants, for the county, lawyers, you like that too because you'll move things, but I was so looking forward to the relief of not having massive dockets and not having so many cases that we can't get to for trial.
And we appreciate it, that the fact that both of you are moving your dockets. I know I've been in a more status conference on a Monday in Judge Miller's court in the last year than I've been in any court. So it's nice, though, because it keeps us all on pace. And I've actually been in your court, Judge Reeder, since for a long time. Last one was some flooding case I had, and we were filing motions. We were just making up names to them just to come in and be able to explain what's going on. But
the pallet case?
No, that was a different one.
Okay.
That was similar, but it was another flooding case. Yeah, that was in her court.
It's still that was part of it's still there, I think.
I got a call on that.
Insurance issue.
This part's not there anymore.
Correct.
This part is also not there anymore.
Now they're just fighting over.
Oh, yeah. I got a call. I don't know. I think you called me. Well, you were about to go try it?
Yeah, we were in her trial for pretrial,
Yeah.
and I was in Tanya Garrison's court in an MDL against Kurt Arnold and Tony Busby at the same time, which I'm the only lawyer in the planet that's ever tried a case against both those guys at the same time. And it was, Judge Garrison was concerned because she had an MDL and she had to get it set, but we had an earlier calls number, and she was dissatisfied with I was everywhere I needed to be, but nowhere I should have been problem. But it all worked out. So there you go.
Yeah.
All went away.
Well, that's a hard thing for us to deal with because we're trying to get to our old cases, move our cases, and you just are too popular.
Well, not me, but there's a reality. I think they're the plaintiff's bar's got a ton of skilled lawyers. I think the defense bar has some incredibly talented lawyers. They get asked to help out a lot more than maybe they should because it's just a view that they're the best and they're very good at it. We're friends with them. They're in your court all the time, and it does create problems because my deal was just tell me where to go, and if I'm in the same judicial district, I just sometimes have to ask where do I go. The problem is when I was in 2 different places. In 2 different judicial districts, then it became, where do I need to go? Right. And it never bothered me. Our friends, we have them now. They just tell me where to go. Monday morning's Monday morning. I just need to know where to go.
The problem's going to get better, meaning that we all are under a mandate by the Supreme Court and the legislature to move our cases faster. So better meaning put your seatbelt on and get ready to go, especially when these 5 courts come along.
Yeah.
After Harvey and after COVID, I think the bar was not aware of how halftime the courts were, and once COVID got settled in after COVID, I think you saw a lot of lawyers switching law firms and moving up and down to fill those spaces up because you have 24 courts on board for the first time since 2017,
And everyone's working.
That's the hard part now, and these continuance. I know the mandate down about the continuances. Plaintiffs lawyers, we don't love the continuance idea, but sometimes we need it, and now we're getting ourselves in a bind. So it's let's get ready, and you never know if it's going to be having to go get tried because I haven't seen a continuance granted in a long time.
Yeah, and things are moving, and you all know this. You get a trial date, it helps your cases move. We're moving a lot of cases, and we're getting through the old ones. We tried a 2024 case not too long ago.
That's
first trial
awesome.
setting, and we're ready.
First trial setting?
I think so. First or second, but it was definitely a 2024 case, so it couldn't have been
Were they ready?
much. Yeah, they were ready.
Because the chance, it used to be.
Yeah.
Yeah.
Now you're number one.
It's like when
you
it's
can't
first
really
trial
do that
setting.
now. And look, and had they not been, I'm not. I give some people some grace, but I think it's a lesson to the bar to know just because it's your first trial setting doesn't mean there's no chance you're going to get called.
Harris County Rocket Docket.
Be
Let's
ready.
go.
Just be ready. And if you need a continuance or if you're not ready, be ready to tell the court why and when you will be ready so that we can be reasonable about how much time we give you.
And some of us aren't giving continuances necessarily. We'll reset the case because there's another number being kept out there. We're not sure what it really means.
Right.
And so, my court just call the coordinator and say, can we get reset? And we'll be realistic as much as we can. But it's easier to do that. Of course, if it's opposed, then you have to
file a motion. But if it's just if you're not ready and you need another month or two, just call the court, ask for a reset or to be taken off the trial docket, ask for a status conference. There's ways if courts are not wanting to grant continuances because of some of that data.
And I think that's helpful, knowing that. Let's say, hey, I can do this next month, and there's a strong likelihood I'm going to go.
Yeah.
That's a lot more helpful for both sides, I think.
Right.
Then you're like, it's almost set in stone, if you will.
And I think that's where, I'm not trying to make you be ready for a case that needs to get tried when you're not ready. But there's a difference between that and pushing someone to trial versus folks that are constantly never ready. And it's like, if you're not ready now, you're not going to be ready in 2 months. You're not going to be ready in 3 months.
Yeah.
Like, you've got to make your decision at that. And those are the ones I'm going to be less inclined to work with. But if you tell me I need 2 more months, we've got to get this thing done, we got to get this thing done, and we'll be ready to go, great.
Yeah.
That's good to know, and I bet that's helpful to everyone because some of us are coming with our tails between our legs. We're like, we're petrified to tell them we need more time.
Yeah. And look, I can't speak for the rest of our colleagues.
Yeah.
I mean, there's 24 of us right now, and we're all handle things differently, and so I can only speak for how we handle things, but that's why it's always good to know the court, know the coordinator, know the staff, be nice, so that you can get some of that intel on how the court's
That's really good words for younger lawyers, too, that it's not just the judge you need to know.
No, it's actually not the judge you need to know at all. I mean, it's great to know us, and I think that it's great for young lawyers to get to know the court, but if you can get in good with the staff, that's where you're really going to learn the things. They're not necessarily going to give you preferential treatment, but you're going to get insight on how the court runs. You would just be surprised how many people are so mean to the staff or throw the staff under the bus.
Oh my goodness, yeah.
And that doesn't ever go the way that they think it's going to go.
I think the lawyers
I don't know why they would think it'd go well.
I really don't either, but
they're so passionate sometimes, and my clerk will
clerk
tell
said
you
this. It's like, well, yeah, but
I think the lawyer should contact the clerk or the trial coordinator and develop that relationship with them. Hey, a staff member they may not communicate what you want to communicate to them. I always enjoyed it myself because I would try to always kind of sweet talk them into getting what I wanted. It eventually kind of works, right?
Yeah.
You really notice it when you go to one of these small towns with one judge and one coordinator, and then the guy's walking in the back and having a lot of fun, and you're like, probably should have done that.
Right.
They'd come back and hand you the order. It's
Yeah. Well, we didn't get to have the hearing, though.
Yeah.
and we had it. You weren't invited.
And the bailiff, for sure, right? If you're in jury trial, there's no one closer to the jury than the bailiff is. And so I had a case once where I got along really well with the bailiff. He wouldn't tell me exactly what was happening, but he gave me a very good indication as much as he could. But if you don't treat the bailiff right, then you could be in real trouble because they have the best relationship with the jury.
That's true. We actually just tried a case in a court over here. I won't name what court, but we got along really well with the defense side, and we were sitting there.
As you should.
And we were chatting. We were chatting, but we would get loud, and that bailiff, he's like, "This is the friendliest group of lawyers I've ever seen," but he goes, "You guys get so loud, and this is not proper for the court." He goes, "No more talking to each other." And so he's like, "Well, you guys can talk to each other, just not so loud, And it was just really funny because you're like, this is a guy you really can't piss off, and so it's like you learn every day you're in trial, and especially in a new court, what kind of works, what doesn't, and like with now my colleague Judge Englehart trying a case in his court was really fun because if you spoke as fast as I'm speaking right now, you'd get stopped in the middle of everything. So it's just. I think it's important to know your audience, know your people, and go in. So it's fun.
Does he have a sign Judge
He
Hawkins
did.
has a sign.
He
Slow
did
down.
have a sign. So
Hawkins
slow
has a
down.
sign too.
Hawkins has a sign now, and didn't know that.
I'm surprised. I didn't know she had a sign.
She had a sign. Whether she still has a sign, I don't know. But the last non-trial, but really could have been a trial, extensive multi-day TI was hold the sign up, slow down. I can talk fast too. But
You get in the moment and you talk fast, but
Norma has never told me to slow down, and I can speak very fast too. So
I get told sometimes, but especially if you're reading something. Know that if you're reading something in court, just slow down.
Yeah.
Slow down.
yeah, it's hard. You just get so passionate about it, and then sometimes you forget your train of thought, and then you speak very slowly, and it sounds even worse. You're like thinking of something else. Yeah,
words to
and it's that squirrel that runs out in the side of your eye, and you're like, huh, what was I saying?
going back to trial settings, is special settings still a thing? Or are they so stacked up they're no longer
prep
special?
setting, the preferential setting.
I press that a lot.
They are. I prep set a lot. Yeah.
And sometimes you press at the lawyers you can't get because they're so busy around the courthouse in other counties.
And I'll do prep set number 1, and I'll give folks an option to be the preferentially set number 2 behind a prep set number 1, and they'll know that, and just watch the docket. I also, though, on sometimes when lawyers say I really need a special setting because my client's out of state and I need to make travel arrangements or something like that, and it's a shorter case, what I'll say is, look, I'm not going to give you a preferential setting because I don't think it necessarily, there's no other really special reason to give you a special setting, but it's a 2-week trial docket. I won't call you the first day. We can, if you're going to get called, you'll get called in the second week, and I'll let you know at least a week before. So at that point, it's not a preferential setting. You're not getting 24 hours notice. You'll get a week's notice.
The second week assignment's great.
Yeah. So I do that a lot.
Yeah.
When folks are asking for a preferential setting and I'm not willing to give it, I will give them this, second week setting so they can at least know, okay, day 1 of my 2-week trial docket, I'm not just going to immediately get
Because
called.
it's often our peer group, we're not ready to try the case. It's often we can't get our experts. So
Yeah.
experts. And for a young lawyer, make sure you tell your expert witnesses what the trial date is, because you're going to call them and say, hey, we're trialing a week. And they're like, I'm not going to be there.
Right.
I'm either on a cruise ship or I'm in surgery or I'm doing whatever else. I found the problem getting experts to meet, particularly now, because there's there's few counsel, there's few experts, and they're used a lot. And you don't go out and take a discovery depot for kicks because you don't want to have to play a video the whole time of trial, which right now we're playing a lot of videos in a case I'm currently in, like 25 or 30 hours worth of
Death by
videos.
videotape.
Judge Miller loves
So-
that.
That's my favorite.
So we'll talk about
Yeah.
recommendations on video cuts next. But make sure you tell your witnesses if you want to call them live at trial when the trial date is. Lesson learned to everyone. So tell us about how awesome jurors love to watch video during trial.
For 45 minutes to an hour.
You don't even get 'em popcorn and a Coke, right? So
Right.
it's probably the most boring thing there is. And no one wants to hear more about C5, C7 and on a videotape than they do in person. So I do have a rule. I sound like I'm a dictator, but I guess I kind of am in the court. But things I've learned. One of our first trials out of COVID was 4 witnesses by videotape and 1 live. There's nothing worse for a jury and a judge too, because we try to protect the jury so much. So I was in the well cutting the videotape during breaks and saying, this is this, because you have people that like to just reiterate. And if you guys don't object, then we don't have control over that witness. If the witness is live, we have great control. But once it's videotaped and you guys are being nice to each other, you're not being nice to the jury. So I have a rule: 20 minutes per videotape per side, without leave of court. You can always ask for more, and I have, don't tell anybody. I've most likely given more, but with restraint. I do make a joke that if every minute that you go over, and I think it's wasted, I take off your closing. And so that helps incentivize them.
He just did that to us just recently. That's why.
All right. See?
I was like, I know if
Yeah.
he's pointing because he remembers he did it to us, but
Mine is 30 minutes per
you have
witness
one.
per side. I do. Yeah. Or without, with leave of court to have more. The thing is, too, I mean, you all know this. I mean, no one that's taking a deposition is taking it as effective as you would in court doing a cross-examination or a direct examination. It's a more informal setting. You're asking all the questions. You just got objection form over and over and over. And so it's not even just like you're having to watch a video, the examination is also just not as good. And so I really think that when you're deciding to play a depo, sometimes you have to. It's the old, you've got your expert that has to be presented by depo. You've got some element of something that you have to get in. Fine. But find like the shortest amount that you have to play. I've had lawyers play a 3-minute depo clip, 5-minute depo clip. And those can be powerful when it's just a very succinct witness. Also, when you do your depo cuts, watch your videos before you play them. Don't just do your cuts.
That's really good
and put it
advice.
up, because there will be long pauses or things that when you're reading it, it sounds good, but when you see it, it just is not as persuasive as you want it to be, or it takes longer than you think it should. So watch your clips, and if you're already getting bored and lost, the jury's going to be, and just think like, what do I really need this? And most of the time you don't. I put people on clocks also if your case is going to be longer than 4 days, if you're going to have to go into 2 trial weeks, because we're only in trial 4 days a week. And so, when you're on a clock, I'll have people in the middle of trial, actually, no, we're not going to play this depo. We're not going to play this depo. We're not going because you don't actually need it.
I just did a podcast about Pennzoil v. Texaco, which tried in the 151st, and Texaco actually did something worse than playing depositions. They did not video any of their depositions.
Did they read them old school?
They did 8 weeks of that.
Oh my goodness.
To start their defense. And as some of the jurors wrote books about their experience on the jury, and they said that Texaco put on the worst case humanly possible. They also didn't put on a damage model expert. They didn't count their Pennzoil's damage model. So that's
I
also
could have
another.
shortened things.
The basics.
The basics.
There's
So-
viewers that don't know at one point that's how you took former testimony. Someone stood up and you read Q&A to your law partner.
Some
your
people
associate.
still do that when they
eight
don't
weeks
have a
of it.
video, and I've had people do it.
But aren't there the famous stories of the old school guys like Racehorse Haynes or that generation of lawyers?
Dramatic.
They would show to the courthouse and they read the deposition out loud, and that was their first time learning about the case. So they would call the depositions and read it to the jury.
We can dress up now with a wig. We can make a whole scene, like a production
Going to
about it.
the video, though, going to your point, take it out, is oftentimes the lead trial lawyer has no idea what the depo cuts are. They have no idea how much predicate's in that's been repeated through 9 different witnesses, that so-and-so built the bridge. The jury knows that. So-and-so built the bridge 25 times in, and it's just lost. And then we will then say, you have to take this out.
Yes.
But it's on us as lead not to do that. But when you're dealing with 1,000 other things, it's not, one of the priorities.
It's hard, especially, depending on what kind of law firm you're at, how you're practicing. One of the, it's usually an associate that's doing those depo cuts. It's when I was at a big law firm, that was what my, tasks was. But the partner or whoever is the lead trial lawyer needs to be looking at, when you're building the story of your case and the theme of your case, you've got to go and look at how those depo cuts play and watch them like you're watching your case and see how is that arc building, because you think you have this amazing story and then you're bogged down with 3 hours of depos and you're lost in it.
So a good trial strategy is not, hey, we need some filler.
Right. There should
I
not
got a
ever be
podcast,
filler.
throw on the
Should
video
not ever
so I
be
can
filler.
come down.
Who can we throw
Yeah.
in there
Time.
Yeah.
before lunch?
Yeah, well, maybe
that can be right.
That's a different one.
That's true. That's different if somebody's running late, you've got a witness that's not there, and you've got a judge that's gonna be mean. Well, if they're not there, you can have something to do, I guess.
Speaking of depo cuts, one of the biggest learning thing that I can probably give someone for that is send the judge the transcript,
Yes.
because every time they have to rule on objections,
Yes.
and they're like, I don't know. Yeah, what do I rule on?
You just expect me to know the transcript.
And so I learned that the hard way.
That has to be one of the
a
worst
couple
parts of
years
the
ago.
job is reading highlighted depo cuts for a big trial.
It is. I do it day by day too, because I have made the mistake of over the weekend on a big case. It was going to be a 2-week trial. It was definitely going to trial. So I spent, I don't know, 8 hours over the weekend doing depot cuts for the entire, all 25 depots.
You getting those back?
And it settled, of course. And it had settled on a Friday, but they didn't tell me until the Monday. I was not very happy about that. So now I've learned my lesson. And if it's a long case like that, I just have lawyers tell me, who are you playing tomorrow? Who are you playing the next day? And I'll give you the cuts.
And it helps because we change them so much through from day one. We usually are more all-inclusive.
Correct.
And then we're like, okay,
yes,
now I can sit down and focus on this one.
So, and I say, that's fine if you're going to do amended cuts. Now, it starts to run into some things, and if the other side had counters, and then they want to put that back in because they didn't put, this piece in because you're playing it, but it usually all works out.
The trial's not super easy, right?
Yeah, right. It turns out it's,
Practice point. Have y'all seen people take the opponent's adverse witness and call them adverse by video in their case in chief?
Yes.
I think once.
Okay.
I think once.
Did you just do it?
No, but I know that I know there's some people in town, not so much in town. I know people do it. It's if they went to someone, if a defense said, now I'm a mercenary trial lawyer, plaintiff side, but when I was doing a more defense-oriented practice, we get jammed up. It's like, hey, we got to get proof. We got to take a video depo, and you take a, typical trial depo, and then the plaintiffs would come behind you, crush them, and then call that witness in their case in chief, largely starting with their crushing, and then you can't replay it all for background. It's just a gobbledygooked mess as kind of a trial strategy. I didn't know. I know people that do it. I didn't know often.
I've seen it happen.
Yeah. And it can be effective if done right. And I just did the ritual doing it because someone did it once and gave a speech at a CLE. But when it matters, it matters.
Right.
Yeah.
I mean, the other thing that's come up too is somebody will want to call someone adversely by depo, but then the other side will want to call them live, and then they'll say, well, then they've already played their depo. They don't get to cross-examine them.
But that's not the rule.
That is not the rule.
Yeah.
That's not the rule.
Yeah,
it's an interesting argument, but no, you don't get to hide behind that and
it's fun to do that.
Yeah.
Well, the rule would be what? So they call somebody adverse. They can either take trial direct right then or reserve to their case.
Yeah.
Right.
Okay.
Yeah, then you get the second bite at the apple.
Right.
Yeah.
It's for any purpose, right?
And you can play counter depo designations at the time and then call them again.
Trial is talking about trial is really fun. The actual preparation for trial is miserable because of all the deposition cuts and all. I mean, these 2-3 week trials.
Can I chime in?
Yeah,
on
please.
The one thing, I don't know if you see this, but get your disclosures up to date and be pragmatic about it, because certainly when we get to trial and nothing's been updated or they're inadequate, we're dealing with that instead of dealing with what we really should be dealing with. And those fights can be avoided.
That just happened to you in a case, right?
I think it happens every case I have.
It does. Well, as a practice pointer goes, the lawyers should be updating their interrogatories, maybe calling their client and saying, hey, did you verify this is your testimony, not mine? Are you really blaming this poor elderly woman comparative fault in a case or not? Let's not do that. Let's amend our answer and withdraw comparative fault in a case that doesn't deserve it 31 days out of trial or by the DCO deadline in your two fine courts.
I also think, I'm shocked how many witnesses, parties or not parties, but folks who have been deposed have not read their deposition prior to trial.
Oh.
Do you all tell folks to read their depos?
Yeah, absolutely,
okay.
Yes.
So they just don't listen to you.
Well, it's also it's just the unprepared witness, right? It's just the unprepared plaintiff sometimes.
Right.
Just visit with your. I know that some of our
Everyone's
cases
busy and quick, but
are
it's just
busy,
shocking
but-
to me how often someone it's usually when they're going to impeach them, have you seen this deposition before? And they're like, no, I've never read it, I've never looked at it. Really?
Do people typically impeach properly in your courts?
No.
I've heard that's one of the hard. That people mess it up constantly.
and they look at you like, I can't help you. I'm not going to tell you what to do. Do you tell them what to do?
I don't tell them what to do.
Randy Wilson wrote a very good state bar article a long time ago, laying proper foundation out of a beach. And I lived by it. And then I was trying to case in Dallas, and if it's a party witness, you don't have to go through the ritual anymore. And I jumped up and objected to foundation, and the lawyer slid me the rule. I'm like, never heard of that rule before.
When the rule changed, it did, and that I think that piece sometimes gets missed in it. Although it's been long enough now that, but no one does it right. or they want to impeach with something that is not actually an impeachable statement.
It's
It's not a statement. Yeah.
It's not red light, green light.
No.
I was in
not
the trial,
sexy anyway.
It's not.
and I asked the guy. I said, "Have you done this work before?" Maybe once. Depo, I knew. He said none. And then I got a handwritten note saying impeach. I'm like, I never gonna impeach the difference in none or maybe one. It's not worth it. Red light, green light.
It's
Maybe red
it's,
light, yellow light, but certainly red light, green light.
it's just not sexy.
It's not
not
sexy.
as exciting
it's
as
just always
you think.
like
Well,
that's a big
Why do
thing.
they think it's important?
Credibility.
No, why do lawyers? Is it just, man, I got him because I'm thinking
think
like a lawyer
so.
and I'm not thinking like a juror?
Yes. And I think, the way that most of us when we were younger lawyers were taught to craft a cross-examination is through the depo often, right? And so you have your tabs to know where to impeach and kind of go through that. But it's not exciting. It's not getting you what you need.
That's
And
not the aha moment you think it
No.
is.
I mean, I feel like I could probably count. There's maybe been a couple of times that truly someone has said something so outrageously different in their depo, and then have had to say, well, something, I've learned something new since then, and it really did undermine their credibility. Most of the time, it's things that we can explain, or there are things that, well, you asked it differently, and then the witness starts arguing with the lawyer about
turns out great.
Right, and it all gets fumbled, and the jury's sitting there like, what is the point of this exercise?
You're wasting time.
Yeah.
That's fair. It's good to know because we laugh when we're with appellate attorneys at trial and they're like, "You're not doing this right." You're like, "We know. I know I'm not doing it right, but I'm trying."
But if a judge doesn't know and you get away with it,
Yeah.
then awesome, right? Because then you can make it more dramatic.
Yeah, that's fair. I guess that goes into speaking of the kind of doing trials. What do y'all think about objections and objecting a lot, objecting a little? What do juries see?
So what I tell folks, you can always tell young lawyers who are in mock trial, who are wanting to win mock trial in the courtroom. And it's not that. You're not getting points for every time you object. You have to be strategic about it. They have to decide, does it matter? Sometimes the stuff you're getting, or they're giving you, is like, for instance, the leading objections. Yeah. I agree. Fine. If someone is just completely leading their witness, fine, object to leading. But don't object to leading for every single question. Although it can really throw off your opponent and they can get flustered. And so you just have to think about, what is the purpose of my objection? Is it truly because there is an evidentiary point that is, so prejudicial that we should not get into it? Fine. And hopefully by that point you've had a motion in limine to talk about that. Because if not, if it's just a question that's like, calls for speculation, but it's like a very reasonable question to ask, just let things go, because the juries are smarter than we think, and they understand it. I personally get very annoyed with the non-responsive objections during a cross-examination. And I understand sometimes you have to do it. But most lawyers that do it are pretending like they're in a depo. They don't even wait for a ruling. They just say objection non-responsive and move on.
Middle of the answer.
And then I'm like, what? Like, do you need me? Are you just trying to say that so the jury hears? It's just, I think you can do a much better job controlling a witness through cross-examination by laying better ground rules in the beginning, getting the witness to agree with you on how things are going to go, and leading them that way, than getting into an objection non-responsive argument.
What do you do?
Been a while, but I don't typically object all that much.
I don't either. If
I
they
don't
can
even,
fix
especially
it by
in-
restating it, why object?
Right.
Yeah.
Hearsay, sure. Calls for legal conclusion, sure. Stuff that I know I'm going to get a yes from the judge, or at least have a fighter's chance, and it's going to take the question away.
Yeah.
If it can just be fixed, then what am I doing?
I mean, I treat it like a deposition. Where I don't object much during a
Do you object to
deposition.
form a lot during trial?
Yeah, I've done it before, and I was like, "Boy, stand up and say something." Like an objection form came out of my mouth, and I was like, "No, I have about 5 seconds to think about what that
We've all
form
done
is."
it. We've all done it.
It is and it's
Objection,
so-
this is bad for me.
Yeah, like it is.
or during a bench trial, they object to the judge's question.
gosh, yeah.
That happened last week.
That's awesome.
How'd you rule?
I love the courage. Did they have a tie on? I know he had a tie on. She had a tie.
And they knew they'd messed up, and they were like, so sorry.
Objection.
Yeah, I overruled it.
That's great. You
What do you
this down.
what do you do with do you care about objections? Do you like that?
I think that you're developing a relationship with the jury, and so if you're being obnoxious, the jury is going to discount you a bit, and you're developing a reputation with the judge. And so if you're being and the court reporter, right? So the court reporter in her transcript or his transcript is going to be a mess with this stuff. So I prefer, look, I will get direct in trial, and if it's annoying, I will maybe tell them to stop in front of the jury, if we've talked about it before. I think if it's a running objection you want, then talk to the judge, outside the presence of the jury and say, hey, we're going to discuss this. You already ruled this way. I want a running objection. Will you do that? And I will almost always say yes. So I think there are ways to handle those tough parts. But if you're going to be obnoxious and object all the time, I probably will overrule you most of the time. We were in baby judges school. They did this chart of error and when judges are reversed, and it went all the way up here, and rulings on objections was
it's like
never.
Right, because
It's
it's
never.
just such a discretionary call in the moment that, again, we're not talking about like a substantive exhibit, right, where you're objecting to the admission of something. And to Will's point, we're talking about the objection to the admission of some piece of evidence, whether that be a document or whether it be some subject area of testimony that either is going into hearsay or going into, something that's more prejudicial than probative. Fine. I understand we have an objection, and hopefully during a pretrial conference, we've had conversations about that. There's either been a motion to exclude or a motion in limine, because that's kind of a subject area on admissibility. That's different than just objecting to the way that someone asked a question that can rephrase it. And you usually know when I'm like, can you just rephrase your question, counsel? Why are we going through that exercise?
I had a lawyer tell me, Judge, I'm going to object to every question. I said, you will not.
Because what are you preserving error for? What are you preserving?
No. The answer is no.
Do the juries think lawyers are hiding stuff from them? They over object? We've been told that as trial counsel.
I would think so.
I would think so, too.
And you're being obstinate, and just let the testimony proceed and deal with it. Right? That's your job, is to deal with whatever comes out.
Sometimes I will actually get their permission. Say, judge is a judge. I'll throw a red challenge flag from time to time to object. You might hold it against me if I think I need to do this, just in case.
Yeah.
There's he's hiding stuff from us because you don't know who they are.
Is that a real question for voir dire, though?
It's probably not, but I do it.
No, it's not, but you do it. You get away with it. You get away with it.
You wouldn't get a cause strike if someone said, I'm going to hold that against you. It's just information.
It's much more. I got a veneer who I don't know who's going to be there yet. I don't want one of them who is unidentifiable to say he's holding stuff back.
Yeah.
Well, I'm going to inoculate that with one throwaway comment and what.
I think what jurors more, when they think that you're hiding stuff, is not so much multiple objections, but when they start seeing a lot of bench conferences and you're getting, anytime a lawyer is trying to get into something and you're standing up and running to the judge, they're like, what's going on?
Does may we approach hurt you a lot more than...
I usually say no. And I'm like, it depends, because there's some lawyers that every time they objection, can we approach? No, we're not going to have a million bench conferences. And I will tell you in pretrial, look, we've talked about the motions in limine. We've talked about the issues on kind of big evidentiary buckets that may come up. When this is going to happen, I kind of want you to signal this, so maybe we can take a break. We can talk about it outside the presence of the jury, so you're not coming up every single time, because then the jurors do start to kind of wonder, and they're not supposed to, and we can tell them all day long, that this is just part of what we do. And I try to tell them that. Sometimes we have to talk about pieces of evidence and things and how the trial is going to work. But it just starts to, jurors have said, it takes them out of the trial and of the story, and then they're thinking more about what the lawyers are doing, and you don't want them thinking about what.
Well, this is something you learned in the 7 years.
I guess so. Yeah, it's true. I also hate wasting the jury's time, and so do you.
I hate it.
And any time that a witness is not answering questions on direct or cross examination, you are wasting the jury's time, in my opinion.
Or when you show, you're ready to start, the jury's ready to go, And the lawyer's like, well, we got to discuss something
no.
or something else or something else, something else. Like we could have done this.
Correct.
You know, I want to go back. So I do think that a good artful objection in voir dire is helpful for a judge, because sometimes you lawyers go on about, you know, will you hold this against me and not hold this against me, or especially defense lawyers. They have all this time they can spend, and they're not going to a bias or prejudice. They're just getting to know the panel better.
It's better for them.
It's better for them.
Because the plaintiff's lawyer spend their hour dealing with mental anguish and money.
Yeah.
The defense can come in and personalize themselves and their client and just shoot the breeze.
But there's a proper objection that you're not asking questions that lead to a bias or a prejudice. And that
I've never had anybody.
But I don't know that you. I mean, I don't know.
I'm gonna
I
use
don't.
it.
I don't think every
Me
question
too.
to the jury has to be something that would
No, I-
go to a bias or prejudice, right?
They're just tribe building, then that's not really what they should be doing.
yeah, right. So
Which we all-
artfully,
Yeah.
but artfully, but I think you have a lot of defense lawyers who don't have to do as much work as plaintiff lawyers that use that time.
Thank you for saying that.
That use that time. They use the time wisely to build this relationship up with them, but some of it's inappropriate. And I think that an artful objection is good. I've had it happen before. It's like, I agree with this. We can cut this short. Even opening two, there's certain lawyers that are so argumentative in their openings, and the young lawyers are so scared to object to it, and so they let the older lawyers just argue their case because they're so scared to object to it, and that takes a lot more time too. Like, just tell us what the facts are going to be and be done.
yeah, but that's so fun.
It's faster.
It's a second opening is a second closing,
Yeah,
Judge.
exactly.
You know that.
Come on, that's no fun. Can't
First
say-
closing, actually.
Just tell me the facts. We don't even need openings. Let's just. We don't need trials. Just give me the.
Yeah.
It's trying cases. It's hard. It's just really hard work, and there's so much stuff that's going on through your mind. And I think I had one juror tell me, he's like, it's like your eyes are thinking, like you can just tell you're thinking of the next thing.
Yep.
And I was like, it's like your eyes are screaming essentially. And I was like, oh, that's
great.
good to
Your
know. I was
eyes
like,
are screaming.
That was like my first
That's an
couple. And I was
image.
like, that's like one of those things that I need to like work on. I was like, how do you?
Your
work
eyes
on
are
that?
screaming.
Yeah.
Your eyes are screaming. Well,
Why
I
is it-
think that's like the opposite of Tyra Banks, like smize, like smile with your eyes, like scream with your eyes.
Yeah, there we go. As my 2.5-year-old said yesterday when I
right.
turned off the lights, he's like, I can't see my eyes, Dad.
Well,
Well,
you're like, oh gosh.
Me neither.
That's a really existential,
I don't know what's
crisis.
going
I don't
on
know
there.
what's going on. I think that's why when you're talking about prepping for trial, we often don't talk about the jury charge until the end of trial, right? And we ask for a proposed charge, and we kind of look at it at the end. But I think it's important. I like to start to look at the charge at the beginning of trial, even though I know it's going to change because I want to know the roadmap. I think when you're prepping for trial and deciding what depots to play and deciding what, even maybe not even prepping for trial, building your case, deciding what depots to take, deciding what motions to file, start with your jury charge. What is going to be, and how are we going to charge this jury at the end of the case, and how can we walk backwards to get there? Because so much of what I think lawyers do, it's like, how does this fit in with what we're going to be asking this jury to do at the end of the day? What questions are you going to be asking this jury, and what instructions are you going to be asking from the court? And then how can I work backwards to figure out what evidence I need to support that?
So let me ask you lawyers this. So is there a strategy for making it all very cloudy so the defense counsel or plaintiff's counsel is guessing at what you're going to do, and that just eats into time, and you're not going to do it at all, but you're trying to make them work for your strategy?
For trial?
Yeah.
Yeah.
Trial.
I'll be honest with you. The last few cases I've tried, we tried the case that was not discovered. It was just a curveball. It was disclosed. The experts were in the case. There was enough there, but the model of the case wasn't this case we ended up trying. And was it intentional or unintentional? I don't know. I get the benefit of coming in a lot is fresh eyes. And it's like, I think lawyers are the worst about confirmation bias. I love this case. I love this case. I love this fact. And if you talk to normal humans, they're like, that fact means nothing. That's a silly fact. I mean, y'all see it every day with real common folks because they just came off your jury, but that lawyer thought they had something cool to say. I get the benefit now of coming in a little bit and saying, I think you're too committed to the cause here. You got too much confirmation bias that you're right. Let's toggle. Let's bob and weave a little bit and see how it works out.
And sometimes you like Will says, if you go focus group your case, let's say 2 months before trial, 3 months before trial, because you're getting ready, all of a sudden they tell you something that I was not focused on this. and I'm not purposely trying to muddy the waters, but I have to kill you this part. But apparently this part is what the 12 jurors will think about. So it's thinking on the fly again. It's not purposely muddying you up, but
Both sides do it.
sometimes you have to do
That's
it
a
because
defense lawyer. I used to get so focused on stuff, and then you had to stop and think: is the jury going to care? One, is it even going to be admissible? Question number one: what venue am I at? What jurisdiction am I in? Is it coming in? If I'm in Travis County, and I'm like, hey, I got this guy that's got found with a bag of weed. I'm in Travis County. It doesn't matter.
Yeah.
But some insurer might look at that as like, hey, this is some big point to make. We're going to devalue the case. It's like, you shouldn't, because that's not going to matter at all. But we both do it. I mean, both sides do it.
Can I put this? It's becoming more important for me in my health. But you all realize that Judge Reeder and I will try case and then case and then case and then case. And sometimes this is not yours, but your only case you're trying that month or sometimes that year. And so you expect the judge to also and their staff to come early and stay late and come early and stay late. And I used to do that, and I'll still do that if I need to, but I realized that I was trying the case like I was a lawyer and not like the judge that I should be in protecting my staff time and my time, because I was at the courthouse early and at the courthouse till 6:30, 7 o'clock at night to deal with things for the lawyers that we should have dealt with before. And so just my own comment to everybody else who might be listening is, we have active trial courts. Judges need lives too. And just because this is your only case you try this month, it's probably not our only case that we try that month. So please look at what the judge also needs for their own health and well-being.
And the lawyers too. I mean, I think that there's something to be said for, right now, lawyers taking care of themselves, judges taking care of ourselves, mental health, substance abuse, all of those things are, unfortunately, such, big issues within the legal community. And we have to really look at what we're doing to put pressure on ourselves that's making it harder for us all to do our jobs and worse for your clients, et cetera. And I think it's what you want from a judge is someone I've been spending a lot of time thinking about these things too, not so much for my own physical health, but my mental health and just the clarity that is important to me, thinking about how to be a good judge and what it means to be a good judge. And you want someone here who's efficient, who's quick, who can make quick snap decisions, overruled, sustained. What's relevant? Is this more probative than prejudicial? And in order to do that, in order to be a good conduit of that information, I need to be free from some external stress, feel aligned in my values, feel aligned in what's important to me. And so I've really been trying to figure out the integration of silence and mindfulness practice, poetry, which is kind of a callback to my former writing days. I have a BFA in dramatic writing. How can we use all of these other forms of consciousness to help align ourselves, for me as a judge, so that when I take that bench, I am in top shape to give you all what you need. And I think it's important for lawyers to think, how can you kind of hone your craft and take care of yourself so that when you step into the well, you're kind of being a good conduit of that wisdom also.
Is the bar getting better at that? I know it's
I think
recognized now. It's lost the unfortunate stigma of I can't be honest about my emotions.
Right.
I can be honest about needing help from someone else, to go sit with someone, talk to someone, get better as a human.
Yeah.
I hope it's better.
I hope so too. And that's why I don't know anecdotally, but that's why I'm trying to be outspoken about it, because I think that the stigma and just it's because of the nature of the adversarial nature of our practice. But I think that we can pull from other industries to realize it's actually really important for our craft, for us to be kind of have a more holistic view of how we're doing things. So I just try to start by that by
What
example.
do you do to stay centered?
I don't know.
Next question.
Yeah.
Yeah, he's like centered.
So I really do try to maintain a workout schedule. It's hard with running for office. It's hard with trying to keep your court going. It's hard with the administrative duties that you lawyers probably don't know that are behind the scenes. Like Judge Reeder is the administrative judge for our civil trial division. I have been that. It's not an easy job. So the fact that, and she's got a family, and I've got one dog now and a partner. But keeping that 2 jobs, which is running for office and being at the office, kind of overwhelms your being. And so I've really tried to, I really try to work out in the morning. If I don't do that, it's a big deficit in what I do. I should do more meditation. Judge Reader's trying to get me to do that, and take that silent time, which I get scared with, quiet time, and we fill that all in. It's just to sit there and just think through it.
But silence is great.
Silence is great, and I've heard from many lawyers it's really helped their practice and their well-being and their home life. So that's a goal.
And also silence is important. People are very uncomfortable with silence generally, and I think lawyers even more so. But when you're talking to a witness, I mean, not in trial, but when you're taking a depo, I mean, just sit there for a little bit. They're going to volunteer more because they will feel that silence, and it's usually that next thing they tell you that's the thing you really want.
Oh yeah, we tell our plaintiffs, just silence is okay. Just you do not have to say anything.
Getting comfortable with silence is a really, I think, useful skill both as a lawyer and as a human.
Yeah, I agree. It's like when the kids go down and you sit on the couch for a second and you don't have to talk to your spouse. Everyone can sit and just enjoy the moment for at least 5 minutes.
On the flip side, though, I think we have jurors, and one of the things I think is interesting and a harder thing for you all as trial lawyers, when our jurors are sitting there for 8 hours a day in the jury box without their phones, having to listen to something. I mean, we are not used to that. We're so used to, even I pick up my phone, I check my email, I scroll. We have our rituals, even when I'm not thinking about it. And so our attention spans are just so stunted, and our jurors are the same way. And so asking them to do what we're asking them to do is not only difficult just because it's a hard thing, but it's difficult because literally our brains are wired differently now. And so you all have your work cut out for you, and I don't take that for granted. But just remember that when you're playing those long depots
the 30-minute
or doing
depo
other
clips, yeah.
things, like you're going to lose your jurors.
Hey, you don't know what's happening in their own lives. So, and that's important too. I had to release a juror because what was happening in his life was very emotional. Someone was dying. And I thought we had an alternate. I thought it was the proper thing to do. But I told the lawyers about this. Which one? Like, that doesn't matter right now, right? What matters is you have someone who's hurting emotionally because someone's dying and they want to be there for that person. Similarly, we don't know what's happening in other people's lives that are there. And so making the best use of their time, I think, is really, really important. And whatever that trigger is for them may impact what their decision is or who they decide for. We got just really dark people.
No, but it's hard. But it goes on to the whole wellness aspect of this. It's hard to know what's going on with even the lawyer that's up there beating up on somebody if they have to. You have no idea what's going on in their life. And so it's just part of our job is getting to know people. It's hard to do it when you get 30 minutes, 45 minutes to question 60 people. It is really hard, and I think
Why
that's
did you
why
look
I
at
think.
me for the 30 minutes?
Well, because I remember you changed it.
Is yours based on case?
Yeah, so I had very early on someone who I respected that asked for like 90 minutes for a car wreck case. And I said, sure, I guess so. Be careful what you're doing, the defense lawyer, but okay, fine. And like the first 45 minutes was about how the juror woke up and started their day that day. And he pulled every single one of them. I was like, never again am I going to do this and subject the panel or myself to this. Now, the big cases, of course, you hour and a half, and I famously gave Steve Kirker 3 hours on an MVA case.
And he didn't waste any time. I don't think.
I was.
He doesn't watch every episode on mine.
I know. Tommy, tell him I said that. Yeah.
I was. He does a very good job of voir dire. He does a master class, people say. And I knew the defense lawyer famously will ask one question. And so it was during COVID.
I was there. I was there.
He was a guest.
I actually told this story. This was our first episode. This was the Shane Osborne.
I'm not going to name names. But you kind of knew, and it was. I was entertained. My staff was less entertained. But I think that the right thing was happening, and I was just curious about where he's going with things. Because some things he opened up with were kind of personal with me, like why is he asking this question? he eventually lost the case. I mean, I think he talks about that too. That he lost that case. So, but it's an interesting case.
Shane's smiling right now. He's watching.
This is great. Is there anything else? I know
We have to end the judicial series with at least say, tell us your pet peeves.
Okay.
Oh yeah.
You can't, because again, we have an audience that will learn from these pet peeves,
Cut out
even
that
if they're
part,
in other cases. And not just basic stuff like don't waste jurors' time. We get that.
Right. Wear a tie.
I still am astonished people can go to court.
Don't put
And-
your feet on the table.
That's right.
Will.
Don't do that.
Okay, there's a story to be told on that. I had the pleasure of trying a complicated case in Judge Reader's court. I got a text message I coach a mock trial team with Christine Weems, and one of our students, who was in May, so he's getting ready to graduate, texted me. It says, putting your feet on the table was a power move during your cross. And apparently what I was doing, I leaned back and I put my feet like this at one point for just microsecond. And I was mortified.
As you should be.
And emailed my wife and said, are you watching the stream? She said, yes. I said, did I have my feet on the table? She goes, I didn't think so.
I don't remember seeing it.
So
but-
I'm going to go with, I had an allegation, unproven allegation. And when we all click the live stream, we can't record it. So it's an unproven allegation.
But don't
And a
do that.
lesson learned that I don't drift
And you,
off into
and you
fantasy
told
land.
you told on yourself earlier.
That's true.
So
Well, some of it's just zone. It's you and the witness. I mean, I don't look at jury. I'm trying a case literally right now, and I can't tell you a single identifying criteria of 12 jurors and 3 alternates. Don't look at them. Don't know what they look like. Don't know how they're acting. Don't care. Not my deal. We'll find out when the jury comes back. So
That's the defense counsel in him.
no, that's the,
Okay, but pet peeves. Do you have pet peeves?
I have one.
Substantive ones?
Yes, I have a substitute.
where do
I
I begin?
substantive.
What do you?
Do we have another hour?
yeah, no sneakers should be a stipulated fact too, Bob.
We like each other a lot, really. So, final charge conference. I have a huge pet peeve, especially, in any case, but if the bigger the case is that if you haven't brought it up to our attention, my attention, at the other party's attention, before the final charge conference, if you have an issue with a question, how it should be worded, or anything involving that, and you raise it up for the first time in the final charge conference,
Do you mean the formal, like when you're on the record?
yeah, and they
People do that?
yeah.
Oh, no.
And they go, well, Judge, I think it should be this and this and this instead. That blows my gasket for many reasons. One is we are in a final charge conference, and it does matter. We've worked so hard in those cases to get it right. You're bringing up something in the last second. So now if the jury's waiting, or we've got a meeting to go to or something else, now we're dealing with this thing off the record. Now we got to research it, look it up, spend time that we could have spent better outside the final charge conference overnight or whatever. And so it just blows up things. And I don't blow up, but I that's a real pet peeve of mine. And I generally tell all my lawyers that do not do this.
That's shocking. That
didn't know existed.
that is shocking to me that someone like because we're not talking about just making your objections on the record or
No,
tenders.
no,
This is just literally someone bringing up an argument they didn't bring up
Yeah.
in the informal charge conference.
We shouldn't do this instruction or this instruction for the first time. And
I
because
would
we
still
found a
not for
case
that.
on this, we did this, and da-da-da. It's like, no. I mean, yes.
Right now,
This
I
had
have
to have happened
Yes,
recently,
now,
I'm
Yes, I'll
assuming.
go back.
okay,
but, but
add that
no.
to my list too. That's a pet peeve. Don't do that.
Yeah, don't do
But you're talking about doing it in the informal charge conference.
Correct.
We're all just sitting there
Obviously,
chatting, having
yeah, we've got to have those conversations.
And if you disagree with my decision on that,
Right.
then yes, tender your question.
Yes. But by the
Do it.
time we get on the record, we all know what everyone's going to
Yeah.
say. You know what I'm going to overrule. You know that what I'm going to reject.
Fair.
We're going to go through the dance. I'm going to sign your thing, your million things that you're handing me. But
So, I still don't know what preserving error
Yeah.
is, but we'll get there one day.
And sometimes you do it right, and most times you do it wrong.
Right.
And they look at you like, give this to the clerk, and like, well, why don't you do it? And like, it's not my job to do that for you. And if I keep it, I'll lose it.
Yeah.
So give it to the clerk. Yeah. So that's a big pet peeve of mine because it's not using time wisely, and we are. The other side is not prepared to talk about it. I'm not prepared to talk about it. And getting the charge right, as we all know, is one of the things we really have to do, or else it'll come back at you. And the last thing that we want to do is have a case come back to us for a new trial after 2 years or 1 year on appeal. And you all don't want that either.
No.
No.
Well, unless you lose or something.
Yeah.
I guess.
This is obviously assuming we won.
But anyway, so that's
Yeah,
my
I don't. I
substantive
mean,
one.
I know we've talked a lot about just sort of do's and don'ts. I mean, I think for me, a pet peeve or something that really kind of gets under my skin is when lawyers make accusations against other lawyers that are unfounded or just misrepresented. I mean, if you're going to ask for sanctions against another lawyer, and really say that their behavior is unethical or they're lying or they're misrepresenting something, I mean, it needs to be really egregious because, I mean, you are asking me to make a finding against a lawyer. And so often, just because someone made you mad or didn't do what you wanted them to do, that doesn't mean that what they did was sanctionable. And I find lately that lawyers are very quick to ask for sanctions for behavior that is probably not sanctionable. And really, if you could, it's kind of like, if you keep having a problem with someone, maybe you should kind of look at yourself too, and what you may be doing to contribute to it. I mean, at home, your partner, also with opposing counsel, because oftentimes if you can approach it differently and confer differently, maybe y'all could have come to a resolution. Not always, but it really bothers me when lawyers are very quick to accuse their counterpart or opposing counterpart of something that is unfounded.
And it just takes time away from things we could also do. I mean,
You're taking up a motion that I had to read, a response I had to read, a hearing I had to have over something that is, y'all could have dealt with.
The problem is those cases that some of that personal vendetta just rides that case forever.
Sure,
It just
yeah,
gets worse
that's true.
and worse and worse.
it becomes more about the lawyers than the case.
Exactly.
And that's a real disservice to the clients.
You ever move for sanctions against a lawyer? I know.
Once when I was first year lawyer, my boss asked me to do it. Won it.
Yes, sir.
I won. That was the only motion for sanction that I ever filed, and I won it. And he was very impressed, and we got, I think it was like $2,500 or something. It was great. I was like, this is awesome.
There are times
easy.
There are times when it's warranted, but most times it's probably not.
Yeah. No, sanctions, not typical. I ask for them. If you can't work stuff out, like having to hear a motion to compel, I bet it's awful for you guys. But when you're going through
Why?
RFP number 36, and I'm like, I can't do this. This is
Yeah.
like, just please, can I have it?
Yeah.
Just please.
Yeah. Or not conferring. And so I send
Yeah.
an email. I'm going to follow this in 6 minutes. Are you opposed?
Maybe that should be the sanction. Like if you don't
Yeah.
confer, you're sanctioned.
You're just going to be handing out sanctions like Oprah out here,
I know.
right?
But
You get a sanction.
But you get a reputation like you must confer in his court.
Yeah.
I mean, I'm not going to do that yet. But, it's important to have a reputation that you've got to do certain things the right way. I don't want the wrong reputation,
Right.
but I think that if people know your expectations, then they're more likely to follow them versus, not having expectations.
It's amazing what happens when you confer, don't get anything, file the motion, and then all of a sudden it appears.
Fine. Fine, which,
You did what you needed to do. You did a service to your client. It just took some time to draft a motion, but you get what you need.
But then some lawyers will still come down and say, actually, I still want my fees for having to do this motion. And sometimes, maybe, depending on what it is, but generally it's like, no, this was like part of the
called
game.
being a lawyer.
It's part of the game.
Yeah.
And sometimes it's because the other side had client issues and they needed that to get things moving. I mean, you never know.
Judge Miller didn't see that in anything in one of our cases. Yeah. So, well, no, this has been lovely.
Awesome. Thank you for coming.
You're welcome.
We'll have a whole episode on preserving error one day and learning what it is and figuring out
Led
what
by
it is.
Omar.
Yeah.
Right.
You can't come to the office and do a CLE. But no, and I would be remiss if I didn't say, we love having you guys on the bench. If you do go out and vote, please do Judge Lauren Reeder and Judge Bo Miller.
Thank you.
Keep them on the bench because we love them here and they're fair.
And I think in today's political climate, that's not just March. That is also next November as well.
That's
Yes.
right.
So vote twice, not the same time. But
Just anytime you go vote, just look for my name. It's there. Check it.
Perfect.
Or write it in.
Yeah.
It's 234th and 190th.
Well, thank you for
Thank
having us
y'all.
on.
Thank y'all for
Thank
having
you.
us.
Much.
Appreciate it.